So real property environmental law. This morning we're going to look at the nature of real property. What is that? What are the different ways that we can either own real property or own interests in real property? Then we're going to talk about the different ways that we can transfer real property. We're going to look at some special issues in landlord-tenant relationships. And then if we have time, at the rate we're going now, we may or may not get halfway through, but if we have time, then we're going to talk about some environmental law topics. So the nature of real property. First, I think it's helpful to distinguish real property from personal property. Real property, when we say real property, this is another one of those words that can have a different meaning in our everyday use of real property versus the legal meanings of real property. So when we throw around the word real property, we think about real estate agents, right? And selling houses and land and things like that. But it goes much deeper than that in legally speaking. So real property would be land, sure. It would be anything growing on the land. It would be anything built on the land, anything attached to the land, walls, fences, trees. It would be anything below the surface of the land. So your ownership in real property would not just be what's above ground. Your ownership interest would extend down to subsurface rights and whatever mineral oils or water or whatever could be found down there. And then you go upward too. You've got the right to, it's not unlimited into space, but you do have ownership of airspace rights over your property as well. So real property encompasses all these things. Personal property, on the other hand, are things that we can move around. So the closest we probably would get in blurring that line would be if I had a camper or a mobile home on my land. I can move that and take it away. That's not part of the real property. But the house I build there is. The shed that I build there is. You have to be careful too, because real property encompasses all these things. The best term to use is to use the term real property, because that connotes everything on the land, everything above the land, everything below the land. That's all real property. But sometimes if you see real estate contracts, or if we're just talking and you say premises, well, then that can suggest that you just mean the house or the structure that's built on the land. Right? So we just need to be careful about using the right terminology of that. So we talked about the fact that you have airspace rights. I mean, obviously that doesn't go to space. You don't have the right to keep airplanes from flying at 40,000 feet altitude over your house. You have the right to keep airplanes from flying directly over your house, but I'm not aware of where in the law we draw the line of just exactly how high your airspace rights go. But when we talk about violation of airspace rights, it's more things like my neighbor's roof is extending over my property line into my airspace, or there's a tree that's growing slanted or crooked onto my property, or there's something that they're doing in their yard that is, if I would build invisible lines going straight up from my property lines, that is somehow encroaching into those. Subsurface rights are interesting. We don't, in the American South, you don't see too much land speculation or investment in subsurface property rights as you might out west where there's oil, or where people are mining things, but you certainly have the right to mine or extract whatever is below your property. Where you get into some trouble on that is that if you're excavating your property, you've got to be careful that you're not damaging or compromising the foundation of your neighbor's property. So you can excavate to your heart's delight, but you can't do it in a way that's going to make your neighbor's property collapse or in some way compromise the security of the soil and the subsurface of their land as well. there are, as you can imagine, often many conflicts between landowners when one landowner is digging right next to another landowner. So your real property, as I mentioned, includes anything growing on your land. So that would include crops. If you're selling farmland and the crops are growing, that's considered part of the real property. Once you cut, let's say you're growing corn. I sold my farm, it has a corn crop on it. Then if I sell the real property, that includes the corn. If I cut the corn though, then the corn becomes a good. And at that point, it becomes personal property that I could then sell. That part does not go with the land. That's getting a little too deep into the weeds here, so to speak. Fixtures are items that are attached to real property in a permanent way. So if you are ever buying a house, the question always comes up, well, what comes with the house, or what can I take? So things that are built in or attached are usually considered part of the real property, like cabinets, windows. Those are typical fixtures. Refrigerators are personal property. Those are not attached to the real property. They're not fixed in. They're not so associated with the character of their property that they have to stay there. So the key for determining whether something is a fixture or not is just really if it can't be removed without substantially damaging the property. I think cabinets is always a great example of that. You go and rip the cabinets out of a kitchen, then the buyer of the house is not going to be happy about that. Or if the fixture is so adapted to the rest of the realty as it's just become a part of it. The lecture notes say that the key to determining whether something is a fixture is the intent of its owner. I don't think I necessarily agree with that, because determining the intent of an owner is a tall task, and I think that presents a whole raft of problems. So that's something that comes out of the publisher's outline that I'm not sure I totally agree with. But that's the nature of real property. When we say we're dealing in real property, those are the things we're talking about. So let's flip to ownership interests and leases. How do we own real property? And when we do that, what does that look like? What do we actually own? And there's a hierarchy. Well, I shouldn't say that, because I don't want to imply that as I go through these, we're going down a hierarchy. But there's a variety of different ownership interests that you could have in land. But we'll start with the most absolute, complete one. And that is called fee simple absolute. I don't know why it's called that. I suspect that is inherited from our English common law tradition, but it's not a term that really is easy to understand or connotes something that's easily understandable in this day and time. But fee simple absolute, if you hear that, that's the highest form of ownership that a person can have over property. That means you have everything. You have the right to sell it, use it, pass it down to whoever you want. If you die, it means that it passes to your heirs. It's yours, and it stays in your family for as long as you want it to. That's fee simple absolute. It lasts forever. There are no limitations or conditions. So if fee simple absolute is the most complete form of ownership we can have, I like to think of it as a bundle of sticks. So think about all the different rights you would have in property: to use it, to keep people out, to profit off of it, to mine what's under it, to grow crops on it, to build houses on it, to do whatever you want with it, to pass it down. There's a stick for each of those rights, and they're all bundled up in fee simple absolute. But when we take that bundle and we start sliding a stick out here or there, then we get ownership interests that are less than fee simple absolute. So for example, if I take the stick out of the bundle that represents the right to own it and do what you want with it, as far as transferring it to heirs or selling it forever, we could end up with a life estate. So what a life estate looks like is I deed my property to my wife. Say it's in my name. I deed it to her for her life. And then at the end of her life, the deed would say who it goes to. So these are not that common anymore, but you still see them sometimes. Anybody have any real life experience with a life estate? So So what that looks like is if I deed that property to my wife for her life, and then to my children, let's say when she dies, I don't own the property anymore. It's not mine. My wife owns it so long as she's living. So while she's living, she has the right to enjoy it, grow crops on it, build houses on it, knock houses down on it, do anything she wants to do, but she can't sell it. Well, that's not entirely true. She could sell it, but if she sold it, the person she sold it to could not have any more than the property for her life. That's still going to be a condition on it. So at her death, she doesn't own it anymore, and it goes over to what we call the remainderman, and that would be whoever I left it to after her life estate. Sometimes you'll see it these days in like a situation where a property owner is married for a second or third time, and if they predecease their spouse, they're going to leave the property to their spouse, but then at that spouse's death, it would go to the original owner's children. We see that sometimes in estate planning as a way to, keep the first set of children from evicting their stepmother or stepfather when their parent dies. But that's a life estate. I don't think they're very useful, and I think they can devalue property, but there are some situations where I guess they're useful if it fits what your need is. But those are life estates. So that would come with all of the ownership rights except for the ability to own it in perpetuity and pass it down to your heirs. That's one of the rights that we would pull out of the bundle. The person who has the life estate, we call them a life tenant, and they have some responsibilities. They can't waste the land. They have to maintain the value of the property. They can't burden it with like a lease or a mortgage that would last beyond the term of their life. They're not allowed to do those things because once they pass away, then their interest ends. So they can't give away more than what they have in the life estate. What you see much, much more commonly, because we have property ownership in the name of married people all the time, and we have property ownership in property we inherit with our brothers or cousins or sisters and all those types of things. Those are concurrent ownership. So there's some different forms of concurrent ownership that many of you should be familiar with. The first one is, well, I'm going to tell you the three of them because I want you to appreciate how each of them involve concurrent ownership, but they each have different features. Tenants in common, you can hold property as, I'm going to make, because these words sound alike, tenants, Tenants, in common. That's a tenancy in common, Tenancy, that's in your notes. A tenancy in common, you could have joint tenants or you could have a tenancy by the entirety. So tenants in common mean that the owners each own an undivided fractional interest in the property. And at the owner's death, whatever percentage or fraction that owner owned passes to his heirs or whoever he or she designates in their will. So Ms. Alderman and I own a house together as tenants in common. When I die, whatever fraction I own will go to whoever I say in my will, or if I don't have a will, it'll go to whoever my heirs are. I don't know why I feel moved to do this, but I'll just call time out for a second while we're talking about wills and heirs and stuff. So I want to make sure everybody understands how that works. When you die, if you have a will, your property will go to whoever you say you want to have it in the will. Doesn't matter how many children you have. It doesn't matter if you're married. It doesn't matter how many heirs you may have. Whatever you say in your will, that happens. So if I have a wife and 4 children, but I want to leave my property that's in my name to my brother when I die, I can do that, and there's nothing that my wife or children can do about that. Where we get into talk about heirs is when a person dies without a will. When you die without a will, the law says who your heirs are and how your property will be split up. Each state can do it on their own. So in Georgia, it looks something like if I die today with no will, then a fraction would go to my spouse and a fraction would go to my children if they're living. If I didn't have a spouse, it would all go to my children. But it can get complicated because let's say that I have 4 adult children and one of my children has already died, but that deceased child has 5 children of his own. So then those children step into the shoes of him. So that's how you get into heirs, and you get into all kind of crazy forms of joint ownership of property in that way. So that's just a quick detour into what I'm talking about when we get into how you pass property down through a will, or even if you don't have a will. So back to tenants in common. You each own an undivided fractional interest in the property. If there's 2 of us, we each own 50%. If there's 3 of us, we each own 1/3. If there's 4 of us, we each own 1/4, so on and so forth. But if let's say that I own a family farm with my 3 brothers, there's 4 of us, we are tenants in common. When I die, my 1/4 share will go to whoever I leave it to in my will, or if I don't have a will, it'll go to my heirs. So there's nothing that the other 3 owners can do about what I do with my 1/4 share. I could sell my 1/4 share while I'm in life if I want to, and whoever I sell it to would then be a tenant in common with a 1/4 ownership with my 3 brothers. That's how that works. Joint tenancy has a twist to it. Joint tenancy says that the owners all have the same undivided interest in the property. 2 of us, 50-50, 3 of us, 1/3 each, 4 of us, 1/4 each, and so on and so forth. But when one of the owners dies, their ownership share goes to the other owners. That's a that is a joint tenancy. So tenants in common and joint tenancy sound a lot like the same thing, but they're not. They have vastly different meanings within the law. And if you're a person who's selling land, or you're planning a will, or you're dealing with real estate contracts, you want to make dang sure that whoever's drafting your deed has reflected the language to be exactly what you want the ownership structure to be. Because that'd be a disastrous consequence if you intend to be tenants in common, but it's drafted as a joint tenancy. And you can see how that would get confused. Because in one of them, in tenants in common, you can pass down your share after you die. In a joint tenancy, when you die, you have nothing left. So that can leave people out. Why do we do this? I mean, people have different ways and needs, I guess, and what their wishes are for owning property. But a lot of times it helps married couples avoid having to probate an estate when they die. So if you own property that's going to pass through a will, then you've got to go to a probate court, at least in Georgia. In most states, they're called probate courts. But you've got to actually take legal action to have this person's estate probated, or will probated, or if there's no will, have the estate administered, so that the deeds can then go out to the proper people who are going to own the property afterwards, own the real property afterwards. But if my wife and I only have a house, that's really our only asset, and it's titled with joint tenancy, then at my death, it just becomes hers. And if I don't have any other assets, then she doesn't have to go through the trouble and expense of going to probate court, paying lawyers, getting deeds done. It just automatically becomes hers. So that's one way that's used. Let's say that, for example, my wife and I own a house as in a joint tenancy, and we get divorced, and she sells her interest in that property to somebody else. At that point, a joint tenancy is automatically, I'm going to say transferred. There's nothing magical that happens, but it by law, by operation of law, it becomes tenants in common. So you can't, if you own property as a joint tenant and you sell your interest, then the new owner and the old owner become tenants in common rather than joint tenants. I know that's confusing. Tenants in common and joint tenants sound like the same thing, but just know there's a world of distinction between those two things. You can also hold bank accounts as joint tenants, and that's usually a good thing too, to help avoid going to probate court when somebody dies, so that, you know, if you intended to leave, if I intend to leave my bank accounts to my wife, then it's easier for me to just own it with her on the bank documents as joint tenants rather than tenants in common, and that way it just automatically passes to her without her having to go to probate. So pay attention to the language, the ownership language, not just in real property, which we're talking about obviously today, but in the ownership of personal property and especially finances as well. You want to know what the ownership is and what that means, both for your right to use it, your right to sell it, and your right to decide what happens to it after you die. All questions to ask every time. The outline talks about something called a tenancy by the entirety. That's really a joint tenancy, but it's when the owners are husband and wife. And the distinction between joint tenancy and tenancy by the entirety is that while they're married, neither spouse can sell or transfer their interest in the property to somebody else. You rarely see those, but that does come up. Community property is in the outline. I'm not going to get too much into that because Georgia is not a community property state. That's a designation that has to do with how assets are held between spouses. California, for example, is a community property state, and it means that it doesn't matter whose name the asset is in. If we're married, it belongs to both of us. Georgia is not a community property state. It's what's known as a separate property state, and I could lecture for a while on what that means, but that's not going to be something you're going to be tested on, but just know when you see that, that's what that means. The takeaway is, hopefully your takeaway is not that you memorize the Georgia law on what each of these things means. The takeaway, hopefully, is that when you are involved in any sort of property ownership or property transfer or estate planning, that you make sure that you understand whatever the terms are that are being used. I want you to remember back. I remember Professor Tebow said, I really need to make sure that I understand exactly what these things are and that we're using the right term that does with my property what I intend to happen with it. Another way that you could own an interest in property without owning all the bundle of sticks is leases. And we're very familiar with leases. Many of you who are here today live in property that you lease. So just as with everything else we talk about, there are different kinds of leases. You can have a fixed term tenancy lease. That is where the time period that you're leasing the property for is specified, and your leasehold interest terminates at the end of the time period. That's a fixed term tenancy. We see that's pretty common. We don't see very many open-ended leases where it just says, I'm going to lease this property and I'll pay rent every month. That is open-ended. That would not be a fixed term tenancy. That tenancy, as I said, terminates at the end of the specified period, so there's no need to give notice of termination because the tenant already has notice up front when they sign the lease. I know that I'm signing a 10-month lease. I know that it terminates after 10 months, so the landlord doesn't have to give me notice. Periodic tenancy is created when the lease doesn't specify how long it is to last, but it does specify that the rent's paid in certain intervals. So if I sign a lease that just says I'm leasing this premises and the rent is $800 a month, but it doesn't have a direct fixed duration, then at that point I just have a periodic tenancy. In a periodic tenancy, the landlord does have to give the tenant notice of when the landlord wants to terminate the lease, because it's not specified in the lease. The law does not allow a landlord to just show up one day and say, hey, your lease is up, get out. You've got to give a certain amount of notice, and that varies from state to state. A tenancy at will is terminable without notice. That is rare, because most states, even when you have a tenancy at will, are still going to require you to give notice. Hopefully none of you have ever been evicted, but, well, I'll flip it around in a more positive light. Hopefully none of you have been landlords that have had tenants that have stayed longer than their lease is, and you want them out because they don't have the right to be there anymore. Let's say we had a fixed duration leasehold estate of 10 months, and 10 months is up and the tenant stays without permission. The landlord cannot show up with a moving company and just unlock the door and move the stuff out. You still got to get people notice. You still got to go through the evictions process. So those are different ways that you could have a leasehold interest. The interests we've talked about so far at this point have all been possessory interests. A lease, you have the right to possess the real property for the term of your lease or for the duration that you're there legally. Obviously, fee simple absolute, that's all the rights. You got the right to possess that property. A life estate, or if you own property as tenants in common or a joint tenancy, those are all possessory interests. You have the right to possess the land and do with it as you want. But there are non-possessory interests too. You can still own some sort of interest in land, but it's something short of the right to possess the land. So the easiest one that comes to mind is, in Georgia, in the South, we call them hunting leases, but they're really hunting licenses. The right to use a piece of land to hunt deer, or the right to use a piece of land to grow corn. Those are licenses. I don't have the right, if I get a license to hunt on a piece of property, I don't have the right to possess it. I don't have the right to do what I want with it, but I have the right to go on it for certain purposes and under certain conditions. Those are easier to understand. There's also this idea of an easement, and your outline is going to go into some pretty detailed distinctions between different kind of easements. I don't want to get into that part. I just want you to understand what an easement is and what the idea is behind it, because these are pretty common. So an easement is the right to use land without taking anything from it. So how does that distinguish an easement from a license? Well, an easement, most of the time you see easement on things like a driveway. So let's say that I own a piece of land that's, I don't know if I can draw this or not because this thing doesn't work great, but let's say that this is my land. And here's the highway right here. And this is somebody else's land. And I'm landlocked. I don't have any access to a road. But there is a driveway or a path to my property from the main road. So I could own an easement or the right to use this driveway to get to my land. Now, I don't have the right to just go demand of somebody else that they have to let me use that easement. That either happens over time. You can acquire an easement just by use of, I use it and they never stop me. We'll talk about that in a second. But easements, most of the time you'll see easements put in a deed. So when I buy, or when somebody else buys that property, if the deed to that land says that ownership of that land is subject to an easement that is owned by the back rear property owner, then that's part of the deed, and that travels with it goes with the deed in each successive owner. So that's an easement. It could be a well on the back of somebody else's property that I need to use to get water. I could have an easement to use the well. Gas companies or utility companies will often buy easements from landowners to put their lines through. You'll see that often. And so there's something you can sell. Let's say I own that piece of back property there and the gas company wants to put their gas line through the back of my property. Well, I can sell them an easement. It would be put in a deed. It would be deeded from me to the gas company, and that would last in perpetuity. And anytime I sell my property, that easement will go with it. So it's not something that, at first it can sound like it's a burden on the landowner to have to let somebody else use their land, but it's not really that way. Landowners are usually compensated for it. It's something we can buy and sell. So those are easements. Anybody have any real life experience with easements? Sometimes they could be driveways. You'll see where two houses share a common driveway, but the driveway is actually located on one person's property and not the other. Those can always be easements, but you'll see those in the deed. So that's another thing to always look for in a deed when you're buying or selling property is, are there any easements or licenses or any other non-possessory interests that my property is subject to? Now, that's not to say that you could never get out of an easement. A property owner could buy it back. So if somebody else who's in front of my land says, I'll give you $10,000, but you've got to give up your easement, then we could do that deal. But there would be a new deed done that shows that I don't own that easement anymore, that's been terminated. So there are ways to get out of them as well. All right, how do we transfer ownership in real property? So up to this point, we've talked about what is real property, and then what are the different ways that we can own it. Now let's move to transfer of real property. How do we do that? Obviously, we can buy and sell it, right? And you see very often that those are done through real estate sales contracts. The reason for that is, that wasn't a dramatic pause, by the way. It's not exciting. The reason for that is that, and this is going to jump ahead to contracts for a second, but contracts in general do not have to be in writing. We can make an oral contract all day long that's enforceable in court. But, as I hope you've come to expect with everything we talk about in this class, there are exceptions right and left. And one of the exceptions to that is that contracts for the sale of land always have to be in writing. All day, every day, in every state. They have to be in writing. So, when you buy and sell land, if you want to enter into a contract that is enforceable for the purchase or sale, you've got to do it in writing. And so we see those done most often in real estate sales contracts. A lot of times they're form contracts because if a licensed realtor is involved, then they're using forms that have been developed by their real estate commissions, and they've been developed for use to make things conform and for continuity is what I'm trying to get at. So everybody's using the same forms. But a contract for the sale of land could be written on a cocktail napkin. I agree to sell my 40-acre farm to Mr. Jackson for $50,000. We both sign off on it. That's a good real estate contract. I won't recommend that, but that's valid and enforceable. So we see contracts most of the time. When property is sold, unless it's explicitly excluded, such as using the words as is or subject to a certain condition on the property, in every sale there's an implied warranty that and this goes for like residential real estate, buildings, houses, things like that it's fit for human habitation. Or in the example of commercial buildings, that it's fit for the use of whatever business that you're buying it for. A seller also has the duty in these situations to disclose hidden defects. So if there's if part of my roof is missing and everybody can see that, I don't have a duty to disclose that. But if there's a big giant hole in my basement that's hidden by a water heater in a wall that is not readily seen, then I've got a duty to disclose that. So those are just some things that come up in real estate contracts. The main way that we legally transfer ownership when we effectuate a purchase and sale is through a deed. That's the only way to do it. Deeds have to be recorded, typically in the county where the property is. That's how it's done in Georgia. But I want y'all to listen to something. And I'm hoping that as I read these, alarm bells are going to go off to you and you'll understand why we have disputes over property and ownership and things like that. So a deed requires the names of the grantor and grantee, words evidencing an intent to convey, a legally sufficient description of the land, the grantor's signature. So the only thing that's required on a deed is the signature of the person who's selling it or giving it. You don't have to have the buyer or the recipient sign off on it. And then you've got to have delivery of the deed. So I hope that as you hear those things, you can think to yourself, I see where we can have disputes over this kind of thing. Even something like the names of the grantor and grantee. Very often property is bought or sold in shell companies or in other entities besides just a person's name. And then we get confused about who actually bought it, who actually sold it, what the chain of ownership is in that. Just the phrase, words evidencing an intent to convey. I mean, what the hell does that mean? Obviously, if the deed says, I give and convey this to you, that's pretty clear, but we could certainly have language that might be much more ambiguous than that. Delivery, what does that mean? Does that mean when I go to my lawyer's office and I sign the deed, does that mean it's delivered to the buyer or the person that I'm giving it to? When I put it in the mail, does that mean it's delivered? Or does delivery mean that the person who bought it or was given the land actually received the deed? These are all ways that there are a lot of gray area in when we're talking about the sufficiency of a deed. So what kind of deeds are there? The best kind of deed, if you're a buyer, that you can get is a warranty deed. That provides the most protection against any defects in the title. So what would be a defect in the title? Title meaning ownership of the land. Not in any, that's not, I'd be careful what I say. In most purchases, title searches are done by title search companies or title lawyers. And they go back and they trace in the deed books of the county record room ownership all the way back as far as they can to make sure that each transfer of ownership, there wasn't a problem with it. If there's a problem somewhere along the chain, then we say that title is clouded. There's a cloud on the title because there's some dispute or there's some defect in the ownership through the years. But a warranty deed gives the buyer or the recipient the most protection, because what that says is that if there is a defect in the title or somebody comes up later and challenges the ownership of the buyer, this was really my land, or I have an easement on this, or some other beef that they have, then the seller is responsible for making it right to the person that they sold it to. They've given a warranty that the title was clear and clean and good. And if there's some problem with that, then they're liable to the buyer. On the other end of that spectrum is something called a quit claim deed. Lots of people say it's quick claim, but it's quit, Q-U-I-T, claim deed. And that has no warranties. That just says, I'm deeding you my property, and whatever I owned, I'm giving to you. If there are limitations on what I owned, if there was a problem on the title, if I owned this property subject to some disputes, then you're getting whatever I had. If there's a problem later on it that comes up or somebody challenges you, that's your problem. You knew up front that all I'm doing is giving you whatever it was that I had. So obviously a buyer's going to want a warranty deed instead of a quit-claim deed. But quit-claim deeds are also, they can be useful sometimes too. That's not to say that they're only used by people who are looking to scam somebody or fleece somebody. They have certain uses, but if you're buying, when you're buying your house or something like that, you absolutely want to have a warranty deed. The deed is not official or effective or evidence of your ownership until it's recorded. So that means that the deed has to actually go to the county. In Georgia, that would be our Superior Court County Clerk, and it has to be recorded in their deed books, stamped in and recorded. That's just required because that's the way that we can ensure a smooth and orderly transfer of property. We've got to have one place where everybody can go and check and see who the owner is. Otherwise, buying and selling real property would be chaos. We would never have any certainty about what it is we're getting. So the rule is that whatever the deeds books say in the records room, that's what everybody goes by. But still, there are different ways that different states treat this. So some states say that the first person to record the deed is the owner. If a fraudulent seller or a negligent buyer who maybe buys property and then just never records the deed, if that happens and we've got two people with deed to the same land, whoever records it first gets it. That's if your state has what's known as a race statute. So every state will say how it works about recording deeds. But if you're in a race state, then the first person to record it is the legal owner. On the other end of that spectrum is a pure notice, what's called a pure notice recording statute. And that means that if you know that somebody else has bought the property, then it doesn't matter who records it first. Another way that property can pass is through will or inheritance. So I touched on this already. If I leave my house to my wife in my will, when I die, my estate will be my will will be probated, and whoever the executor of my estate is will do a deed. It's called an executor's deed or a deed of assent, and that deed goes from the executor of my estate to my wife. There's no sale involved in that, no contract. It's just a deed that shows that I owned it, I died, and my estate is now transferring ownership to my wife or whoever it is I leave the property to. Same thing if I don't have a will. It would go to whatever Georgia law says inherits my property if I don't have a will. And the deed would go from the administrator of the estate to whoever the law says gets my property upon my death. There's this idea, another way that you can transfer ownership. It's called adverse possession. And it's kind of like a hostile takeover of somebody else's land, or a feature of their land or a part of their land. So the example I'm going to use is, let's say that this is a lake. Y'all like my lake? And there's a dock on this lake, and it's on property owned by A, and my property's right here. And I, at some point, let's say that I built a fence right here, a wall, and I just use this dock. A never uses the dock. This idea of adverse possession might give me a claim that basically that's just become mine over time. Now, it's not as easy as maybe I've laid it out right there. Adverse possession requires a few different elements. So it requires, first of all, that the possession, the adverse possession, that's my possession is adverse because it's not really mine. That my possession has to be actual and exclusive. So if that dock just sat there over the years and I never used it, then I wouldn't have a claim to have adversely possessed it. It has to be exclusive, meaning that I've treated it as just mine. If I allow all the other property owners around that lake and we're all using it, that's not exclusive to me. If I use that dock with A, that's not exclusive either. That just means we're both using something on his or her property. So it has to be actual and exclusive. It has to be open, visible, and notorious. You have to be able to look at it and see that I've made it mine. I've put up a sign, Tebow's dock. There's no secret that I consider it to be mine. If it's just sat there over the years and A or any other observer can't figure out that I'm possessing it, then that is not open, visible, and notorious. It has to be continuous and peaceable for a certain time. Now that certain time, if I'm doing my job in any good way for y'all, when I say things like a certain time, the first thing you should think of is well, what does certain time mean? How long is that? So the law's just going to say a certain time. The laws aren't going to say 1 year, 2 years, 5 years, 20 years. It just doesn't. But it has to be continuous. So I've got to have used it continually over that period of time. I couldn't have just used it for a year or two. Then I built myself another dock that I didn't use my neighbor's, but then my dock rotted and fell in and I went back to using my neighbor's. That won't work. I've got to use it continuously. And then the word peaceable for a certain time. That means that there's no dispute over it. I could build that wall. I could use that dock. I could put my name on it. I could keep my neighbor out of it. But if my neighbor disputes that I've been possessing it, he tells me all the time, that's not your dock. You don't have my permission to use that dock. I'm going to sue you to take that wall down. I'm writing you a letter telling you, listen, you've been using it without my permission, but I do not agree that you can. Then that's not peaceable use. That's not peaceable use. So when a situation, let's say that I meet all those. Let's say that A has never objected, has never used that dock, has never given anybody any indication that he has a problem with my use of it. And after 20 or 30 years' time of us doing that, the law recognizes that it's possible that I could have acquired that through adverse possession. So the lesson to you is, don't let anybody else use your stuff without getting in writing or putting them on notice that, hey, I don't agree that that's yours. Don't let them use your stuff anyway, because at their 4th of July party, when somebody, gets burned with fireworks or gets, super drunk and injured, who's the first person that they're going to sue? A, right? Because they're the owner of the property. So don't let other people use your property like that and expose yourself to possibly losing your land through adverse possession. So, the purpose of adverse possession is, it's not to give folks a reason to weasel or steal property from somebody else. It's not to protect wrongdoers. It's really there to encourage the stability of property ownership over time and settle disputes over things like boundaries, docks, things like, maybe not docks, but boundaries. And we want to assure that this property can continue to be passed down or sold within the stream of commerce without all kind of disputes and arguments. So it's really meant to settle. It's really meant to go back and reform a deed to reflect the way that the owners have treated the property. Does that make sense? If over a 30 or 40 year period of time, me and A have treated that as mine, then in order to kind of ensure a smooth transition of property in the stream of commerce. We want the actual property ownership to reflect what we've done in practice. Another way to transfer property is eminent domain. You've heard of that. That's the right of the government to take land for public use. The government does have that right. But under the Fifth Amendment, you are a person whose land is taken is given the right to be compensated justly for it. It's usually fair market value. There are, it's a court process that's involved. Somebody wants to take land for eminent domain. Usually it'll be with the most common way we see it is widening roads out in the country or even in town, I suppose. But they're going to widen a road. They're going to need the landowner's property to do that, and they give notice to the landowner. We are initiating proceedings to exercise eminent domain, take your property. Then it goes through the court process if the landowner wants to dispute it, and the dispute, I suppose, it wouldn't be about whether the government could do it because they have the right. The dispute would be over what the compensation is. But it's usually fair market value is what you get for it. Let's see, we got 10 minutes left. Yeah, I think I can do this all the way up to environmental law. Landlord-tenant relationships. Obviously, the difference between a tenant and a purchaser is that the tenant's right to possess the land is for a very limited duration. Leases, I told you that a minute ago, that a contract for the sale of real property has to be in writing. Leases they could be oral, but if the duration is for a year or longer, they have to be in writing. But the lesson is always, let's don't get into the weeds on whether or not something has to be oral and writing. Just always get it in writing. And then we don't have to worry about whether or not we might have a valid oral lease. Always get it in writing. A tenant has the right to possess the real property exclusively. I rent an apartment, or if I rent a house, that gives me the right to keep other people out of it, including the landlord, except for sometimes you'll see in leases they got the right to come in and repair or show it for sale or something like that. Eviction, we kind of talked about. That is an infringement on the right to use the property exclusively, right, if I'm being evicted from it. But generally, a landlord cannot evict a tenant for no reason. It's usually for something because somebody's breached the lease, or they've stayed beyond the lease, or they've done something wrong to where they need to be evicted. There's also this idea of constructive eviction. That's when they haven't kicked you out, but they've made conditions so bad that you don't have any choice to move out. That happened with a client of mine was renting a warehouse up in Spalding County, and the landlord can't get the roof fixed. Not every time, when we have heavy rains, it leaks. They've got mold problems leaking into their offices. The landlord makes a patch repair and it doesn't work. And finally we told them, we're terminating the lease and we're moving out because we consider that we've been constructively evicted. You didn't come and evict us physically or legally, but you've made the premises such that we can't work here. We can't work with water pouring in our office. So we've been constructively evicted. So there's that idea as well. Tenant has the responsibility of maintaining the premises. The tenant is responsible for damages, not for ordinary wear and tear, but anything beyond that. You guys know this as you've been tenants before. Tenants have the responsibility of paying rent. A tenant can transfer, the landlord can too, but a tenant can transfer their lease to someone else in a couple ways. One is that they can just assign it to someone else. I'm renting this house. I don't want to live there anymore, but I know that a friend of mine needs a place to rent. The friend's going to move in. They're going to take over my lease. That's an assignment of the lease. Most Leases, you see, the landlord will prevent that. They do not want the tenant to have the right to bring somebody else in their shoes, because that is just the landlord losing control over who's staying there. If I'm a landlord and I lease it to person X, then I don't want them to turn around and assign their lease to another person without my permission. So most of the time that's prohibited, but it could be a right. Sublease is not quite the same. Sublease is when my friend comes in and leases it, but he's paying me and I'm paying the landlord. He's just sort of stepping in my shoes. Many leases will prevent that as well. All right, the next topic is environmental law. I'm going to talk about that some on Thursday, but there are just a host of federal laws. Environmental law is mostly a federal area. So Congress is the one that is enacting these statutes that have to do with clean air, clean water, radioactive, hazardous substances, all that kind of thing. And the Environmental Protection Agency, as a federal agency, is the group that's responsible for administering environmental law. And it is an enormous area of law. It's highly technical, it's complicated, and we're not going to get into that's something we could spend a whole year on, is environmental law. And so Thursday, I'm going to go over it very briefly and just want you to be familiar with how environmental law works, what are some of the principles behind it, what are some of the main areas that the government's interested in, and then we'll have I'll have some additional reading between now and then that we'll discuss on Thursday. Any questions from anyone? Okay, we'll see y'all Thursday.